Test, 1, 2, 3. Test.
That sounds good on my side.
Okay, excellent. Thank you. Aloha Chair, we're ready. Begin. Did you unmute? Chair Henderson? Hi there. Yes, we are
Present.
ready for you to call to order. Thank you.
Well, I didn't realize I was going to be the chair of this, but okay. Call the meeting to order for the Board of Appeals on October 12th, 9:32 a.m.
Chair, it's the 13th.
Oh, I'm sorry. I didn't want to say it was Friday. But amend that to October 13th. And can we take a see who is present here? Can you introduce yourselves? I'm Richard Henderson, Chair, Acting Chair of this meeting.
Good morning, Chair. This is Sherry Tavares, Deputy Corporation Counsel. I'm going to ask Ms. Supernat to take roll today of the board members we do have present.
Thank you.
Aloha. Our normal chair, Ms. Aguiar, is excused absence. Vice Chair, who is acting as chair today, Mr. Henderson, has said he is present. Ms. Lewis? Present. Mr. Martin?
Present.
Present. Ms. McNamara?
Present.
And Mr. Trefethan?
Present.
Perfect. And Ms. Psyche, board member, is also excused absence. We also have with us our Deputy Corporation Counsel, Sherry Tavares, myself, staff to the board, April Surprenant, also staff to the board, Ashley DeVera, and staff to the board, Janice Hata. Thank you.
All right. The purpose of this meeting is to accept the pig report and review it. So has everybody had a chance to review the rules and procedures that were amended and distributed?
Yes.
Okay, I'll take that as an affirmative that everybody present has reviewed them. And at this point, what do we have to do to make a motion, I would think, to adopt these rules and then be then open discussion on them?
Chair, before we move into our old business, as on the agenda, if we could deal with public testimony at this time. I believe
Okay.
we have 3 written submissions that were received. I will note that there is no one present here in Kona Council chambers to provide oral testimony, but if we can ask if there is anyone online. No? Okay. There is currently no one present online or physically here in person to provide testimony, but the board did receive 3 written submissions that was distributed and provided to everyone. Now we can move on to our next item on the agenda, which item number 1 deals with BOA-21-000-299, which is a comprehensive review of BOA rules of practice and procedure and proposed amendments. Chair, my recommendation would be, being that we established a permitted interaction group back at our meeting in May, and the group met and delivered its report to the entire board at our meeting on September 14th, 2023, that we now make a motion to have open discussion on it so that the board members who were not a part of the permitted interaction group can provide comment on the specific section, should there be any, before we can move forward with the next step in amending, repealing, or fixing the rules.
All right, so as I understand it, we are going to have a motion to open discussion on the permitted interaction groups report to the commission. Do I have a motion?
I so move.
All right, it's been moved. Do I have a second?
I second.
Well, it's been moved in second. All those in favor, say yes.
Yes.
Yes. Yes.
Yes.
Anybody too contrary minded? Hearing none, the motion is passed, so we can now begin our questions and answers and discussions on this.
Chair, if I could just make one recommendation so that we can go through this in somewhat of a formatted and organized way. I'm proposing that we start and take it section by section so that the staff has the ability to make any notes on the comments that is provided by the board members. And so we can start at the beginning in section 1 and open it up for discussion or questions with anything related in part 1 general rules.
All right, that is accepted. And let me just open my copy since I'm doing this online now.
Chair, we would have the ability to share screen if you would like to have that.
Oh, yeah,
option.
that's right. I saw that up there earlier on. Can we do that? Let's put up the
document.
the document.
It's coming.
Okay, and then I think probably that's going to open on the table of contents. All right, so you'll see in what you have on the screen there in the table of contents, wherever there's red, that's the changes have been made. So let's move to section 1.1 purpose. So we've amended the 1.1 by adding on, in accordance with chapter 91 of the Hawaiʻi revised statutes, any conflicts arise between these rules of practice and procedures and state or county regulations, then state statute, county charter, and county code shall prevail. So with this opening change, it kind of gives you the direction of what we've done with the document in general, and that was to annotate, itemize, and include references to making it more understandable and more readable. Is everybody happy with the purpose?
I just have one question.
Yes.
The order of precedence, starting with the state, county, then county code? Or are they all equal?
April, I mean,
So they cascade in order of precedence. Okay.
Yeah.
Got my question answered. Thank you.
Sherry, how does the rule of law apply in this situation?
Chair, as was indicated by Board Member Lewis, the precedent comes from the federal government, then it goes down to the state, then it goes down to the county level. The rules as it currently stands is how county-wise we operate as the Board of Appeals, but we are required to be in compliance with state law, specifically with Chapter 91, which deals with how we govern and conduct our business as a board. And so, as indicated in the purpose in section 1-1, basically the procedures is how we as a county operate but it is in accordance with state and federal law where it is appropriate.
Okay. Does that satisfy the question?
Yes, it does.
All right. Moving on to definitions. In this section, we've of course edited and corrected things that weren't consistent with punctuation and stuff like that. And that's just in number 1 is changing state to capital S and county to capital county. We've included the appellant and the appellee, giving the definitions in definition as to what they are. And you'll note that number 3, appellee means the director of planning department or the director of the Department of Public Works or a duly authorized representative. So when we refer to appellee throughout this document, it could be either or, the planning director or the Public Works director.
Can I ask a question? It feels like we will be here all day if we go through every change in this manner. So I'm wondering if we might not just go along and see as we go through maybe each page or something, whether people have questions. We've all read it. And you know what I mean? I think we could
Yeah,
really
I understand what you mean. I just wanted to cover some of the basic, internal structural things. And right here in definitions are some of the important parts. But having said that, what we can do is scroll through, and when anybody has a question, just holler out, stop, or I have a question there, and then we can zoom in
And
on
I'm
it.
happy, this is Sherry. I'm happy to kind of keep track of where we are, and just for the ease of getting through this, I'll just note where we are at, and then you can ask the board if they have any questions for that particular section. So we are starting in part 1, general rules. Does anybody have any question or issue with the proposed changes?
No.
I do have one small comment on one of the definitions. That's executive meetings. And it's on page 1.5 or 1-5, subsection E. And sub 1 says to consult with the board's attorney. I'm just wondering whether we should say on matters, on legal matters, just to make it clear we don't consult with the board's attorney about it. We don't get to close the meeting just because we want to chat with her. It's got to be on legal matters. And in 92.5, it pretty much sets that out. So I wondered if we would maybe refer to that. For somebody like the person who made comments on these rules and felt that there was no grounds for that, it would maybe make it clear to the public if they refer to section 9.5 of the statutes, what things are within that purview. It's just a suggestion. Obviously, without it, it still makes sense. And, we refer to section 92.5 throughout this, so it's not unusual. Even in subsection F, we refer to it.
I understand what you're saying, but did you want to cite the HRS section and code in here? So that's in there also?
Yeah, it is like I say, it's in section F, but it's not in section E. But it's okay the way it is too. It just leaves a little bit more explanation for the public, I think, with that reference.
We could include as pertaining to legal matters as permitted by HRS section 92-5.
Yeah, I think that'll work.
Mhm.
Like,
Yes, as prescribed by HRS 92-5.
All right, good change. Is that satisfactory to all concerned?
Yes.
Yes.
Okay. You want to move us along then to the next section?
Are there any other questions or comments with regards to part 1?
Nope.
All right, we can move on to part 2, proceedings before the board, general requirements. Are there any comments, questions, clarifications in section or part 2?
There's a small, there's a himself and a himself on the top of 2.2. That's in section 2-3. See it towards the very end of that little subsection 2-3. I'm sorry, the page numbers and the section numbers both have dashes, so it's confusing. It's 2-3 disqualification of board members. And at the very end, there's a couple of himselves that got away from. I can see why, because if you global search him, you're not going to pick up himself, you know.
Okay, good catch there.
Is there anything else in part 2 that we need to discuss?
Hearing none, let's move on to part 3.
Part 3, contested case procedure. Are there any questions, concerns, matters that need to be discussed and parsed through?
I have one that I just want to bring up for discussion is that we're taking out the in a newspaper of general circulation and in the county. I'm just concerned that the public needs one more layer to be notified. That's all.
Where are we?
Section 3-2, notice of hearing. And then there's notice of hearing.
I believe we, when we reviewed that, I think we kind of deferred, Ms. Tavares, you can correct me if I'm wrong, but that that's been changed now to the point where we don't necessarily have to publish it in the paper anymore.
That is correct, Chair, and thank you. If I can just give the board a brief explanation.
Please do.
Essentially what the notice of hearing proposed or recommended updates deal specifically with us being in compliance with what the current state law is, what has been and was vetted through OIP and is what is currently reflective in HRS section or chapter 91
otherwise known as our sunshine law requirements. I understand the concern, and it is up to the board what it wants to do, but essentially this is what the current state law requires for notice. I do understand that there is concern that there potentially could be individuals that would not otherwise know that we are meeting. However, that information is publicly available with regards to our meetings about where we're going to hold them. They're on our website, on the county's website. And essentially the need for, well, I think it has a little bit to do with the less frequency of people utilizing actual printed publication to receive their information. This provides government boards, commissions, really government operations to be the most accurate and updated with their information. Sunshine Law requires that we have our agenda posted at least 6 calendar days prior to the hearing. And just for board information, and most boards and commissions that I'm aware of, if not all of them, do also provide the public with an opportunity to be a part of our general email list. And so we can individually send individuals a part of that, who are a part of that list, a copy of the agenda when it is posted. Again, this is just for clarification to be consistent with what the current state law is. And it was not an intention of somehow circumventing the notice process. But I do understand your concern, and I'll leave it to you folks to make that determination. I will note that when we have this current requirement of it needing to be posted in a public newspaper, essentially 30 days prior to the hearing, what that requires is that any party who is appearing before the board, who has a contested case matter, needs to give us that notice way in advance of time and does not allow us to make any amendments that could possibly add a case to the calendar, because we are not meeting the requirements as it is currently written in the rules. What this does is it expands our ability to provide a more complete agenda and access to the parties that are actually appearing before the board. So again, that's the rationale behind it. It's basically the state law had changed a lot of it due to COVID and people going electronically. This is what the county council does and what all other boards and commissions are currently practicing statewide. So again, I will leave it to you folks to make that decision.
My concern is that while we meet the minimum standards for the state, that we're not accommodating people who don't have internet access, which we all know in this county is an issue in some communities. And then we have demographically people who are not savvy and using the internet, that if you point them to a website, they wouldn't know what to do.
Well, most of our hearings are not about things of general interest. I mean, this is maybe the only exception. Probably today's meeting might have broader interest than just the people that are involved in the hearing. I mean, I don't know how much people are showing up to hearings on contested cases. I suspect very few, if any, that are outside of the people involved. Maybe that's not the case. I don't know. You guys would know better than me, obviously. But that's why I think there's a distinction here, because if you're in the case, you're going to get the stuff right into your mailbox, you know, right in your inbox.
Your physical mailbox or an electronic mailbox.
If you don't have an electronic, you'll get a paper copy.
Okay.
And if I can just add in there, as what a board member Lewis pointed out, the Board of Appeals does not handle things that are general in nature, say like the county council does. They're pretty specific to a property that has been, you know, either issued a notice of violation or there's something going on for which there is a disagreement with the county entity that handles that specific situation. Now, part of our notice requirements is that
the surrounding properties, the appellant is required to provide notification mailing to them, because those are the individuals that could be impacted by the decisions and what's happening before the Board of Appeals. So for the Board of Appeals purposes, we do have that extra notice requirement for those who would be specifically potentially impacted by the board's decision. So I understand your concern, and I just wanted to add that in for clarification. It's not just about, we don't get to just make general rules that apply to the county as a whole. This is property specific, and we do require the appellant to notify their neighbors.
Thank you for the additional clarifications.
Yeah, and I'd like to say that the permitted interaction group, when we discussed this over here, we kind of weighed in more on the side of the effectiveness and efficiency of the Board of Appeals to address changing circumstances. And it does kind of allow for our caseload to get processed in a more timely manner than if we were strapped to what we had in there before. So that was I would say the over guiding reason why we made that change. So it's if we need to well, let me say, so after hearing the discussion on 3-2 notice of hearing, is there a desire to reinstate the newspaper publishing or not?
I don't think we need to.
All right, then we'll consider it accepted as it stands.
I'm okay.
Okay. Are there any other items contained in part 3, contested case procedure, that the board would like to have a discussion on?
I have one more.
Yes.
Section 316, presentation of evidence. I'm concerned of the time element of the 1 hour. Is that enough time for someone to present all their facts if it's a big case?
I think that on the presentation of evidence, we're going to have had presented to us what they plan to present there beforehand, to review it and understand it. And it would be just them basically coming up with any additional stuff that they had and including that in there. So again, the PIG felt that the 1 hour was sufficient for each side to do that. And I believe that is more in the line of what goes on in the courts too. And Mr. Bars, could you weigh in on this?
Yes, Chair. So I would just preface it with saying this is not a hard and fast rule, in the sense, if I can just be a little expressive and say, we're not gonna just turn off all the microphones and prevent someone from continuing. If there is a situation where more evidence or testimony needs to be taken by the board, then the chair does have that discretion to grant that time. However, what this does is it puts the parties on notice that we are not here just for rambling on of frivolous information. It provides guidance so that the parties, when they do come here, after having sat through contested case hearings, that they're here to present you with their case, and it should be direct and to the point and not have all these added materials in there that could potentially confuse the board on what is the issues at hand. And so I will just say that this is not hard and fast, in the sense that if they're in the middle of presenting and they need more time, then the chair has the authority to grant them that.
Okay, all right.
Okay, And I've been at a meeting where that has in fact happened, where the chair has granted more time. So, I mean, there is a safety valve in this. And it's more just to get things concise and on point and move through the procedure. Okay, moving on, then I
I
guess
have one on 14 about the
314.
briefs.
Briefs,
I'm
okay,
a big proponent of people, especially pro se litigants or whatever claimants, whatever they're called here, the petitioners will write a 20, what is it? What are we giving them? 20 pages? Oh, yeah. Okay, a 20-page, single space, tiny font document. So is it worth just borrowing from the courts and indicating that either number of words or a font, one or the other? Because I don't know, have you gotten those kinds of presentations? They get to put in 3 times more than everybody else that, you know what I mean, sticks to the normal pleadings style. So just an idea.
Yes, I think that we can.
You could say double space 12 point, or, you know, whatever the civil
Mhm.
rules of civil procedure say. A lot of them are going to word count now, so you don't have to worry about which point it is. But whatever you guys think.
yeah,
What is-
again, this was to, allow them, ample paper to submit their brief. But
Plenty.
again,
A lot. I mean,
we want to be able to make them not ramble on, but be, concise in what they're saying. So.
Yeah.
I would contend that 20 pages is not brief.
Yeah,
and so since we're doing that,
Especially
let's
if it's
not
an
let them have
8-point
it
type.
single space, tiny typing, you know what I mean? Any way we could solve that, it would work, I'm sure.
okay, well, we've got double space and 12-point font in there, which
Yeah,
is, I
that
think,
works.
pretty standard.
Doesn't make everybody squint.
Yeah. And so if it doesn't come in that way,
Well, you
can we
know,
reject it?
Yes,
yeah, you can. I mean, it's in the
Absolutely.
rules, actually,
follow the rules.
that they can ask for it to be redone, and should be really, unless it's just a little bit.
So I mean, that's one of the things that, when you start putting, these kind of minutia things in, that you get to, over managing the whole thing. And I think at maybe what we could do is put in at a minimum. For the double spaced and 12-point font.
Oh, so you mean it could be 20-point font? It's fine.
Well, for those who
Triple
don't need
spaced.
reading glasses,
I'm just worried about the length, the number of words really, and that's why courts have turned to the word
Yes.
count. So you don't have to worry about all that policing.
Yeah,
I just don't remember what the 20 pages translates to. I bet I could look it up pretty quick.
No, that's more on the federal rules. The state courts haven't yet.
You still have page numbers?
Yes,
Ah.
and so I think that this recommendation by Board Member Lewis is appropriate, and it does basically track what is currently required by our state courts. And as mentioned, and as Chair Henderson has sat through hearings before, our goal is to be able to get to finality for the parties. And so I think people having to present their issues in a concise format for you folks to be able to adequately address the concerns is appropriate. I think that's a great inclusion.
yeah, great. Okay, does that sum up section 3? Any other comments?
There appears to be none here, Chair.
I just was gonna say that that 20-page, I'm trying to recollect. It's not gonna have to be a global change, is it? I think that just was specifically for the briefs.
That is correct.
Yeah, okay. All right, that's good. Thanks. Moving then on to section 4. Please introduce that.
We are now moving on to part 4, post-hearing procedures for hearings conducted by a hearings officer. Are there any comments, questions, or recommendations?
I do have a question. So a hearing officer is somebody, I'm gonna look back at I'm a little confused, just a little tiny bit. Okay, hearing officer appointed, designated to run a hearing when the chair or one of its members. So you get a outside person coming in?
This section provides for that possibility. should
And
the
that's what
chair-
this is about.
Correct.
So it's different than the typical, okay.
Yes,
That's what
very
I thought.
different,
Yeah,
and it
okay.
provides that backup should the chair and vice chair or a larger member of the board not be able to achieve quorum and sit,
Oh,
or
it's
if
like a
there is.
magistrate almost.
Correct.
but Yeah, okay, got it. So, yeah, okay.
It's if for some reason the board itself is unable to sit and hear it, there is a procedure by which the board can appoint someone as the hearing officer.
Gotcha. Makes sense, yeah. I
Are
just
there any
wasn't sure.
guidelines to establish the qualifications for a hearing officer or any standards or qualifications?
Or are they? Yeah.
Okay.
I goofed up my pages here. You know, one thing it doesn't say in the definition of hearing officer is who appoints the hearing officer.
The hearing officer would be appointed by the board.
Okay. It's got that passive language in there that doesn't, you know,
It's not something that comes up very often.
I bet, right? Never, right?
Chair, if I could offer just what we've done previously in the department.
Sure.
Planning Commission, for example, sometimes defers to a hearings officer, and the planning department will go through procurement through professional services to pay for someone who goes through qualifications to then be a hearings officer. So I would imagine that the Board of Appeals would go through the same thing.
They use them countywide in other settings, yeah.
Yes.
Oh, I should.
Go through, it's a formal process. They have to apply to do it, have to meet qualifications. And then we go through a objective procurement process in choosing an officer.
All right, is that satisfactory for the qualifications and selections of a hearing officer?
Yes.
Okay, that's, I think, the sum of part 4 was just the post hearings. So moving on to part 5.
Yes, Chair, at this time, we're moving on to part 5, rulemaking procedures. Are there any comments, questions, or discussion?
I do. Notice of public hearing. I'm back to the newspaper. Being removed.
I believe Board Member McNamara is referring to section 5-2. Is that correct?
Yes.
Again, dealing with the issue of notice.
And this would be similar to other commissions that the county has.
Mhm.
Yes, Chair, and this specifically deals with Sunshine Law Part 1 of HRS Chapter 92. Again, where the notice requirements was amended in August of 2022, that essentially is the justification for what the PIG created here in section 5-2.
Okay, so do we want to make this? Okay, electronic calendar. All right. Yeah, so I think that, for the general purpose of what our intent is to, bring it in compliance with what the state has in effect, that the language as it exists right now is sufficient. Unless there's an overwhelming desire to, put in the calendar, not the calendar, but the newspaper language. Hearing no
No
need
objections.
to insert that or objections, let's move on. Thank you for bringing up that point again.
No, I just have concerns for the public, so.
Yeah.
But it's be said and weighed out and put to bed.
Okay, if there
Well,
are,
notice on 5.3, Mr. Varus, you want to, that was
Nope.
something that came up, so let's talk about that.
no, Chair, we're fine with moving into section 5.3 if you have something you want to bring up.
No, I'm just saying that what we did there is public hearings for rulemaking shall follow procedures set forth pursuant to parts 1 and 2 of these rules. So that just basically, spins you back to part 1 and part 2, what has to happen there.
So again, this section dealing with rulemaking procedures, which is kind of what we're, well, not
Yeah.
kind of, what we're currently in right now. There is still that requirement for after today's meeting, essentially, we're still going to be required to post 30 days before our next hearing, where we're going to be taking a final vote on the proposed amendments to the rules, that it still needs to be done in that time frame. However, when it comes to our agenda, that is what we were previously talking about. So this section just specifically deals with the process that we're in right now and does require that 30 days posting so that any party interested in coming and giving comment, and we did it this time.
Right.
And as you can see, it was posted in the newspaper, and
We're all here.
we don't have anyone here to join us today. But this language tracks what the state law requires us to do, and that 30 days was not taken out of this.
Okay.
Okay, anything else on section 5.3?
No.
All right, continuing on with the rest of sections 4 through the end. Any questions? Amendments?
We're good here, Chair.
All right,
So if we could move on to part 6. Declaratory rulings. Are there any questions, comments, or discussion?
I have a question on board action. What was the thinking behind moving from 60 to 120 days?
scroll back up. Okay, thank you. I think that when we discussed that, it was recommended that the rationale was to remain consistent with other petition submissions at 120 days, and it also allows adequate time for the staff to schedule the hearing and for council to schedule pre-hearing conferences as needed. So it was more expanding the window to get things done, and I think we were kind of strapped with the 60 days.
Okay, thank you for the explanation.
Okay. Anything further on section 6? Okay, moving on.
We are now going to deal with part 7, variances. Is there any comments, questions, or discussion?
I do have one for section 7(9). The notices to surrounding properties. And my concern deals with the agricultural use land. Is that the 500 feet is not adequate for the larger subdivisions with larger acreage? That maybe that we put in notification also in that situation to their homeowners association, if there is a homeowners association. There are some ag subdivisions that are up to 20 to 40 acres, so the 500 feet doesn't really cover it for notifying the neighbor or the general neighbors or the subdivision itself for the other people that are involved in it.
As an example, Hokulea and is one of those communities. Where
Pardon?
the Hokulea would be a good example of that kind of a community.
Okay,
Also, Kapua farm lots, there are 20-acre ag lots up there.
Waikiki Ranch, Kohala
Yeah.
Ranch, they're all, there's a whole bunch of
Olive
them
Branch
that,
is a good one too.
you know, you're looking at Kapua farm lots is what I'm bringing up, is because
Kohala
you've
Ranch
got
is 3 to 5
questionable
acre
people in
lots.
there that would love to pull stuff and notifying your neighbor. Well, we did, 500 feet, doesn't quite cut it when the rest of the neighborhood is up in arms of somebody doing something they're not supposed to.
I think you bring up a good point when you say, if there is an existing HOA or some such organization like that, should that also be included as one being notified? Mr. Tavares, that's relatively new. We never thought about that when we were doing this thing, but that's a great point. Is there any benefit to doing that, or is that just kind of spreading the net in excess of what really the intent is here?
That's a good question. I live in one of those areas and am in very close communication with my neighbors. I'm part of the neighborhood association, and we tend to be a fairly close-knit community. Not that we're in each other's business all the time, but we do talk. And I'm just curious about that 500-foot rule. What kinds of things, can anyone think of any examples that would make it uncomfortable for your neighbor in excess of 500 feet away from you?
I'm gonna
I
go ahead.
I was just looking for examples of activities or problems, if you will, issues that 500 feet wouldn't mitigate.
Again, back to your larger agricultural subdivisions, with somebody coming in and wanting to do something that would be questionable, shady, that they've, want a variance on because it just kind of a creative way of getting around something. is that notification to the rest of the homeowners in something like Kapua farm lots would be something that would at least stop someone from doing something you don't want them to do. And it would affect all the
Well,
neighbors.
can you give an example?
Well,
Um, With
go
this
ahead.
push to more housing is basically you've got people in there trying to build how it's 20 acres, but it's a 20-acre subdivision, and the law or the county or can't think of where I got this from. They're only allowed to build on the residential homes on one of the sections. They cannot, you've got homeowners that are thinking that they can build on every 3 acres because it's zoned that way. Even they've got 20 acres, and you've got the push for extra housing now.
As a
And-
variance?
Well, who knows what they're gonna pull?
Well,
Well,
I don't
I'm
know
just
if we
saying
can.
That's a variance.
Yeah,
I don't
that's a
know
good
if we can
example of a
identify
zoning.
specific examples of issues that are going to come up because we're not that creative. Expanding the notification zone at least affords the local community that could be affected an opportunity to weigh in and be notified. I think it'd be presumptuous of us to try to determine, the different scenarios,
Right,
because people can get very
Right,
creative when they want to do something.
yeah, no, I know, but that's why I'm saying notifying that
Yeah.
they have,
I-
they have,
Yeah,
at least
I
the,
could see expanding it to 1,000 feet plus and notifying an HOA.
yeah, I'd like to see the HOA notified. And,
Okay, can we look at the rationale for this? Can we scroll down to 8-11?
8,
11.
8,
And
yeah,
section 8 is,
okay. Appeals. I don't think you're.
Chair is referring you to essentially the
Oh, yeah.
procedure.
Yeah,
So if you look
Right.
at 811
it's the same.
D,
It's the same.
right,
Or whatever we do here, we should do that.
no, I agree.
he's referring you to the rationale that's indicated in subsection D. The clarity is what is provided in what's written in the Hawaii County Code currently. That's where the numbers came from. This has to do with the zoning code, and I will just note to the board that you do not have the authority to circumvent building code, the planning department's rules of practice and procedure, and those parties would be here to make their objections should somebody try to be doing that and sneaking around to the Board of Appeals to get some inappropriate, for lack of a better term at the top of my head, structure built. There's requirements that this board cannot waive, so to speak. But I am happy to do a little bit more research when it comes to the inclusion of a homeowners association. I guess the fact that the responsibility is on the appellant, they should know who their homeowners association is, but the board staff in the planning department does not always have contact or information with those entities. And the potential to increase it, the suggestion was to 1,000 feet versus 500 feet, based on different types of communities that we have. This was specific, as is indicated in the zoning code, for agricultural districts. But further, I would just say that it has to do with the potential impact that it has on the surrounding properties, and that's the reason that we require notifying that. But I will look into it more. Again, we are not at the final stage of this process, and I can provide the board with a memo on the research if you would like that. But I think this is a great discussion, and the concern that the board has to ensure that people are notified is great.
but I will look into what the specifics and what the county code currently allows us to do and what state statute allows us to do. Because we cannot make it overburdensome for individual that could feel like we're essentially taking their opportunity from them to the reasonable and beneficial use of their property. But I will look into that and have it presented to you folks before we finalize this section, as well as section D in 8-11.
Okay.
Thank you.
Sounds
Okay,
good.
so the underlying reason for the 500 feet is just basically conforming to what is in existence right now. And I can see the rationale in us not wanting to set our own standards, because we're not the ones that have the underlying jurisdiction to set those. But in dealing with homeowner associations, I know that we've been involved in one of those, and it can get very harrowing when you drag in a homeowner association or an association of apartment or unit owners. And we're not, in the case that we dealt with, it was one of having to try and interpret their own rules and regulations, and that's not what we do as the Board of Appeals. And therefore, it was deferred and told them to go work out, their homeowner objections before they came and made an appeal to us. They were in effect trying to use the Board of Appeals to assert their will on a homeowner association. And I don't know, I think that, adding in homeowner associations or associations of unit owners might be kind of a Pandora's box in here. But Mr. Tavares, if you could look into that and, see if there's any other counties that have kind of leaned that way to notifying any community type associations involved in notification matters, we would appreciate that.
I'll happily do so, Chair. Thank you.
Okay, so we were on 7-9D, notification 500 feet. Are there any other questions in section 7?
Mr. Martin?
If going back to the board and the example that you cited, is there some verbiage that we can put in if we choose to notify homeowners associations that any contention in the homeowners association rules it has to be resolved within the board, has to be resolved within the association, and is not the board's responsibility? Just if we put that in up front, then we mitigate that issue.
Yeah, Ms. Tavares is going to research that notification, and I'm sure she'll come up if there is anything with, what type of language they put in there. But once she does that, then we can come back and address it. And in the meantime, we can be thinking of certain limiting variances on it.
That sounds good.
One other thing I'd like to just draw to the attention is the 20-day prior to the hearing notice. Could that be changed to at least 30? The homeowners associations meet usually every month, so 20 days, someone could file it after that meeting, and it would never be addressed by the board of directors of the homeowners association.
So if I can clarify, that 20 days is not from the filing of their
It's in,
appeal.
7-9D.
It's not 120 days. Oh, yeah,
So-
there, I see.
That 20 days is when the actual hearing will be coming before the board. When we get to the point of the contested case hearing, they are required to notify, if I can just have a second.
If it's okay, sorry, I'm being put on the spot here. I'll just do the research and include it in this entire section.
Okay.
But I think expanding that time, it's not inappropriate, based on the concerns that you gave. So I will
Right.
include that information in the research that I do.
Okay, thank you.
Okay, with that, are we done with section 7?
I just have a really tiny little picky thing on the bottom of 7-11. It says the effective date of the decision shall be the date of the oral decision by the board. I noticed earlier on in an earlier section, which I didn't write down, it uses the term effective date. And I'm wondering if it means the same thing there, and if it does, I think we should move that all to the definitions. Shoot,
11, 7-11.
Yes, the very last sentence
Right
that's
there.
dark that you added. It's the first time effective date is defined, and it's used somewhere else. I wrote it. Oh, shoot.
So this is specifically for when the board is in a public hearing and
Okay,
renders its decision, because that needs to be done in an open hearing.
okay,
That's when the ruling becomes effective, because
Okay.
thereafter, the order isn't necessarily filed at that same
right.
hearing.
No, I get why you put it there, but it was to me, because here it is, it's on 3-19.
Okay, let's move up to 319.
Take a
please.
look at 3-19. I think if you don't want to put it in, I mean, this is a procedure section, right?
Mhm.
Yes.
Yeah, so if nothing else, if it means the same thing there, it should either be included there or defined or something, because I didn't know what it meant in 3-19.
Just for clarification, basically, we don't want parties coming back when it's time for the submission and acceptance of the order to be trying to relitigate their case, because that has
No,
happened.
no, I totally get why it's
Oh, oh.
here, but there's no definition for it here as there is much later in the rules.
Right.
So it seems like the definition should be the first time it's used instead of the second time.
Okay, so your
I don't know if you
suggestion
can
is to
define
give-
effective date.
Yeah, define effective date maybe at 3-19. And whether you do it both times, who cares, but
Okay.
yeah. Because when I saw that, I wondered what it meant, then I forgot about it. Until I saw it later.
Yes.
We just added as a definition.
Yeah.
The effective date is the
Yeah.
date that the board voted on this and actually voted and made an oral decision up or down on the appeal.
But you see what I mean? April, do you see what I mean?
Okay, that's good.
That's all I have for 7.
Okay. Then back to 7, I think 11, the bottom of the paragraph. Or was it
Is
yeah,
there
there it
any-
is, decision.
Yes.
So I think that's kind of like the definition right there.
We are going to add it, Chair, up in section 3-19, so effective putting it in both places, so there is no
Okay.
confusion.
All right. So we've taken care of that little thing. Thank you for the clarification there. Anything else in 7?
Jose, thank you.
Okay, then, moving on to part 8.
Okay, we are now in part 8, appeals. Are there any comments, questions, or discussion regarding part 8?
This is the meat and potatoes.
I do. It would be, under 811 hearings, section D. Again, the 20 days, not less than 20 days. I think maybe 30 would be adequate.
In
Yeah.
section D, you said?
Yes, notice to surrounding, property owners. And then my original homeowners association being notified. Especially for the state land agricultural use subdivisions.
Okay, that's going to be provided by Ms. Tavares when she does the research on that. So section D is notification to surrounding owners. And what this is contemplating is that the board fixes a date for a hearing. So now we've established that now in our second Friday calendar, that you're going to be on this day. And that hearing might not be next month, it might be 2 months from now. And it's basically decided on by the time allotted through a pre-hearing conference on what they're going to need to prepare their stuff. So mostly everything is kind of put in place already through the pre-hearing conference that is establishing the fixing of a date for a hearing. So I don't think that the 20 days prior to the hearing being expanded to 30 days prior to the hearing is really a matter of concern. And the 20 days is kind of like the standardization that we put through the document. But again, you know, we'll look at the 500 feet and the homeowner aspect of the ag part of it.
It just seems like so many people get continuances that it becomes pretty crazy, but that's just my only
Well,
concern.
it's, the continuances aren't a question of a notification, more a question of them putting together their
Yes, but then
resolution.
every time you get a continuance, you got to start all over with the notices, right?
That's why we try and get them to get things and work with the departments to reconcile the difference. And then we do get a lot of, you know, appeals that are withdrawn. And they've actually decided that, okay, you know, they've seen the light and there's no need to pursue this any further.
Chair, as part of my research, I'll provide the rationale for both the 20 days and potentially increasing it to 30.
Okay,
Into consideration everyone's comments.
thank you.
Are there any other comments or questions with regards to part 8? No. Chair, it appears that concludes the questions that board members had with regards to the presentation of the proposed amendments from the permitted interaction group. I will just let you know that we now have an individual who wishes to provide public testimony.
All right, is that going to be online?
Yes, that individual is currently online.
All right, then I will reopen statements from the public on items on the agenda pertaining to the comprehensive review of the Board of Appeals rules and practices and procedures and proposed amendments to accommodate our public testifier.
While we get that set up pursuant to our rules, the public testimony can be for a 3-minute time period unless chair grants an extension. So we can go ahead and see whom the individual is and what they would like to present on, and we'll
Okay.
wait. She's
Thank you.
ready.
Aloha, Ms. Rohr, are you there? You need to turn on your camera.
If it's all right, I'll just leave my camera off. Could I just speak?
If you are going to speak and address the board, you need to turn your camera on.
I don't actually know that that's a requirement. Let me try to get in a good space for that. Hold on. Are you there?
Yes, we're here.
I'm Claudia Rohr. I would say about the notification to the surrounding property owners, the property tax site has a system to generate a list of the surrounding property owners. It's all set up how to do that. So to try to change that would be kind of screwing with the system. So if you're familiar with it, there is instructions for people how to generate that list of the surrounding property owners to make sure you actually did it correctly. That's one thing I would say. The other thing is, I'm assuming that you all read my comments that I wrote in. I work in the morning. I run a bed and breakfast, so I was doing breakfast. I couldn't come in at 9:30. I assume that you all reviewed those. Is that correct?
Your comment.
Ms. Rohr, you're
Mr.
giving public testimony and you are not permitted to question the board members. We did receive and post your 3 written comments, and that was addressed at the beginning of our meeting.
Okay. Okay. The section that you were talking about, the effective date of a decision, to me, that whole thing is confusing because you said we can vote it up or down. If you read the zoning code says that you can do more than just vote it up and down. And there's a disconnect between your rules and the charter and the zoning code, probably chapter 91. But the charter or the zoning code says that you can remand with instructions. But if you look at the exact language, it's more than voting up or down. But I know that there's a tendency to vote up or down at the end of the evidentiary part of the hearing. And then you come back and do your findings of fact, conclusions of law, decision, and order. And this effective, that whole language about the effective date is just basically confusing. And a lot of times you have to just
30
ignore
seconds.
the board's rules because chapter 91 and the rules of court say something totally different about what an effective date is on a decision. So that whole section needs to be reworded or something. You're trying to do something else than what you're saying. The words are just not clear.
Thank you very much for your public comment, Ms. Rohr.
You're welcome.
Is there any other public comment?
No, Chair.
Hearing none, then I will close the public comment section of our meeting and move back on to the agenda. And I believe that brings us to adjournment.
Chair, prior to that, I
Yes.
would just like to, for housekeeping purposes, now that we've had an opportunity in an open hearing to discuss the presentation by the permitted interaction group, and that the board has had an opportunity to discuss and deliberate the recommendations, the staff will be preparing a final draft that is inclusive of all of the comments that were taken in today, and as in compliance with state requirements, we will be doing this in Ramsar format and providing a copy to all of the board members, as well as posting it on our website prior to our next scheduled hearing, depending on the time frame in which that can be worked out. And again, this will come before the board for final approval and any further discussion on those changes and the recommendations that were made. So I just want the board to know that that's what we will now be working on based on the discussion that happened today. And there is going to be one more opportunity and including the research that I'm going to be doing to have final discussion on this matter.
Okay, and there will be the opportunity for public testimony at that meeting.
Absolutely.
Okay, thank you very much for clarification. Does the board agree and understand with what Ms. Tavares explained?
Yes.
Okay. good.
Yes.
All right, thank you very much. Thank you, commissioners, for your attendance. If there's no other business to come before the board, I will ask for a motion to adjourn.
Motion to adjourn?
Second it.
It's been moved and seconded to adjourn this meeting. All those in favor signify by saying aye or raising your hand.
Aye.
Aye.
Thank you all for coming. Have a great day. and a good weekend.
Thank you.
Okay, so